Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is my search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do we need to see?
All right. Let's turn that down. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Have a happy afternoon. Okay? Happy afternoon. How was your lunch? How was your lunch, everybody? I've got issues. We are pool media for the Owens v. Eckerd. Well, we are in the media pool for Owens v. Eckerd. Okay, let me just bring this up on screen. This is the pool media feed I've got right here. I'm not streaming it live to Top Mark because I need to fix it. That's the problem. I chose not to stream this live because it needs to fix. This is the live feed, but that is. Now you can see that. Here we go.
Have them send someone with more
let
experience.
You hear it too.
Doctor test.
What's wrong with this picture?
Correct?
I doctored the test once.
Okay, and when was that?
When I tried to send it to Dave Neal to get him to stop creating harassing videos at me.
And what amount did you doctor?
White balance. White balance is what's wrong.
It was like 102,000, I believe.
Okay. So can you pull up exhibit?
Okay, so we're gonna leave that. Just know that we will have that up on the Top Mark Media channel a little bit. You would not believe that hearing. First of all, it's a paternity suit. We've never followed a paternity case before. We're probably just going to follow this one. It is incredibly fast-paced because both sides are on a time limit. Okay, and so they're speed talking, but it's not sped up. They're trying to fit as much stuff they can. It sounds like a high school debate class in there, going back and forth. It is so spicy. The spicy meter would impress even Ian Runkle, I think. It's been crazy. Anyway, problems. I was talking to the media outlet who's providing the pool feed on Friday. It's the first one they've ever done, and I'm saying, look, you can do it. Here's how to do it. Here's what you need to look for, and I was assured that everything's good. It's not. We've got camera overlays. It was shot on a DSLR camera that commonly will occasionally show just like the screen overlay, like you're looking through the viewfinder, with how much space and all card full error, all that, the battery, it's terrible. Oh my goodness, it's terrible. Many dropouts, camera dropouts, and we get the Elgato. We get audio but no picture. It sounds like it's been run through a USB converter into a laptop to live stream. Not premium. Anyway, Megan Fox is there in person. I know she's there in the courtroom. She's covering that. Dave Neal's covering it, of course. Law Talk with Mike is covering it. But we will have, I believe, the only clean media feed. Everyone else is just using another one that's branded by another streamer. But I think we'll have the only clean media feed out there, which will enable other people to dissect this one as needed. But so give me some time. We'll have that up on Top Mark Media. I could not put it up that way. It's got like cartoony splash screens. Court and break. I'm like this. We agreed on the pool feed. We agreed there would be no branding. We had agreed that it would just be a straight feed, and it is not. And so I've got to trim some of things out. But we'll get that up. Anyway, who's involved in that case? Owens and Eckerd. Owens and Eckerd. It's a former Bachelor contestant. The paternity take a DNA test and prove there's no baby, and that's a sensitive issue, of course. It's alleged that that there was a miscarriage involved. Former Bachelor. Anyway, we'll have that up over on Top Mark. Honestly, it is too spicy for this channel. It's got some stuff in there. Chat isn't on screen. I fix it. Chat is on screen now. I have to give a huge shout out to Greeners, who for the last week pretty much has won the internet every single day. Congratulations, Greeners. The internet is yours once again. Habitual offender. No, most people learn their lesson, Greeners. I'm just saying, most people learn their lesson after a little while and then change behavior. We have not seen that in you yet. I will say that the punishment doesn't escalate with repeated offenses. It's not like the 3 strikes and you're out rule. But good on you, man. Good on you. That's some skill to get there first every single time. All right. I think Greeners and Kimar swapped accounts. They probably swapped strategies. That's what's happening. All right. Where we're going right now, we have a document that we have to review in the Karen Read trial. Man, just looks like, hang on just one second. I'm trying to see what's going on here. Is it over yet? No, not yet. Hey, it's not over yet. Turn that off for a second. I think that's not live. Anyway, well, we're getting it. I'll get it fixed. I'm watching 2 things. I'm watching my recorded copy and the live copy, and I'm getting mixed up. Anyway, here we are. We're gonna go to camera 3, which is right here. We have this wonderful document to review, and it looks something like. Let's see. Can you guys see it as well? You can. All right. Wonderful. It must be Memorex, says Steve. It must be Memorex. All right. As soon as we're able to, I'll put that up on Top Market Media. I might stream it onto it, or I might just load it as a video. I'm not sure which one I'm going to do yet. Let's see. So this is a motion that was filed Friday in the Karen Read trial, submitted by the Commonwealth to the judge. Commonwealth renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. On April 15th, 2024, the day prior to trial, the defendant provided the Commonwealth with a witness list which contains the names of civilians, police, defense investigators, and experts. On April 22nd, the Commonwealth filed Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. During that week of jury impanelment, the defendant was ordered to comply within 1 week with Mass R. Crim P. 14. That's the rule. On April 29th, that's 7 days later, opening statements were made and the trial testimony commenced. The defendant sporadically, provided reciprocal discovery to the Commonwealth on May 1st, May 7th. The defendant's discovery objections includes impeachment evidence allowing the defendant to withhold such evidence against a witness who is certain to be called to testify would undermine the discovery rules and allowed attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. The defendant has failed to comply with the law, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases their opinion. The case law, provides for automatic exchange of discovery regarding intended expert opinion evidence. The Commonwealth again renews its motion for reciprocal discovery. Show us your evidence, they're saying. Show us what they're going to say. On April 15th, the defendant identified Chris Van E., PhD, as a potential expert witness in biomedical and medical engineering. The defendant proffered that Mr. Van E. will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR data obtained in connection with this case. He will testify to the chronological data derived from the EDR, including key cycles and triggering events from the time period in question. However, This description fails to comply with the law, which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. The defendant also identified 3 experts from ARCCA, LLC, Daniel Wolf, PhD, Andrew Rentschler, PhD, and Scott Klein, BSME, as an expert witness in accident reconstruction. The defendant indicated that each expert will testify consistent with the report in possession of the Commonwealth. Pursuant to the law, the Commonwealth again moves for a defendant to produce all written reports on opinions that pertain to this case and the identity of anything upon which the expert bases his opinion. The Commonwealth also moves for the defendant to specify what each of the 3 experts did, what their independent opinion is, and what each expert would testify to. Furthermore, a voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are biomechanical engineers and not crash reconstructionists. On May 21st, the defendant provided the Commonwealth with the curriculum vitae of Dr. Murray Russell, an expert witness not previously disclosed. May 21st, wow. On May 30th, during the 6th week of trial, Attorney Little provided the following synopsis about Dr. Russell. She has reviewed the autopsy photos, grand jury testimony of Dr. Scorti Bello, and the entirety of the autopsy report, all reports associated with Chloe's prior bite history, photographs of the items and evidence, and the UC Davis DNA testing results and evidence submission forms. She is expected to be called with focused testimony related to the right arm injuries sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are consistent with having been struck by a vehicle, road rash, or scratches from broken glass or a taillight material. She will base her opinions and conclusions, inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or taillight material. It's important that they're inconsistent there, I think. She will base her opinions and conclusions in part on having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written reports or opinions from Dr. Russell were provided. A criminal defendant's constitutional right to call a witness on her behalf is not absolute and may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. Case law says the defendant filed, the notice of experts 1 day before trial on April 15th, and for Dr. Russell on May 21st, with a synopsis of her opinions over a week later on May 30th. During the 6th week of trial, for violations of the law, the judge may, in her discretion, bar these witnesses from testifying. This sanction may not be imposed without the judge balancing the Commonwealth's interest in enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. Factors in assessing such balance include prevention of surprise, evidence of bad faith, prejudice to the Commonwealth, the effectiveness of less severe sanctions, and the materiality of the testimony to the outcome of the case. The Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by the extremely late notice of Dr. Russell. The Commonwealth has called over 50 witnesses thus far, and all of them have testified that it was snowing. Witnesses thus far, and a request for a continuance 7 weeks into trial is impractical. In addition, jeopardy has attached. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit this testimony and the surprise it has caused. During a final pretrial hearing on February 15th, when asked by the court whether there was any dispute about K-9's involvement or K-9 DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. It was not until April 29th, during opening statements, where, contrary to the court's prior ruling that third-party culprit evidence was not admissible or appropriate for opening statements, Attorney Yannetti unfairly prejudiced the Commonwealth by arguing, quote, Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did it. And then, surprisingly, proceeded to claim that the defense injuries were consistent with a dog attack. In light of this, on May 15th, the Commonwealth called Terry Kuhn, a forensic scientist, to testify there was no canine DNA present on the samples provided to her veterinary forensic laboratory. Ms. Kuhn did not render an opinion on the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether John O'Keefe's injuries were consistent or inconsistent with an animal attack. The Commonwealth is unduly prejudiced by the defendant's intentional delays in providing appropriate discovery and notice to the Commonwealth. Bad faith when failure to provide discovery is deliberate and willfully motivated by desire to obtain tactical advantage that would minimize the effectiveness of cross-examination and the ability to adduce rebuttal evidence. Furthermore, the proposed testimony of Dr. Russell may necessitate a Dobert Lanigan hearing, where the defendant bears the burden of establishing that the proposed testimony would assist the trier of fact and that the methodology underlying the expert testimony is sufficiently reliable. The trial judge must also determine whether the witness has sufficient knowledge of the facts and expertise to render an opinion. Of note, Dr. Russell's expertise is with treating patients in an emergency room and how injuries may appear on living individuals rather than how injuries are depicted on deceased male in a post-mortem photograph. As for the experts disclosed on April 15th, the Commonwealth again moves an order that the defendant produce the appropriate proffers, opinion evidence, and expert reports forthwith so the Commonwealth can adequately prepare for cross-examination. As to Dr. Russell, the Commonwealth moves for an order to exclude her testimony entirely, as there is no less severe sanction to ameliorate the surprise, bad faith, and outrageously delayed disclosure. The Commonwealth bears the burden of proof, and production at trial cannot try the case while simultaneously working to understand and rebut testimony from experts whose reports and opinion it does not have, without which the Commonwealth is prejudiced and unable to effectively prepare for cross-examination of these witnesses. Respectfully submitted for the Commonwealth, Mr. Lally. Mr. What If Any Lally has signed this. Little asterisk. Should the defendant again fail to produce the appropriate opinion evidence, the Commonwealth may move to exclude those experts as well. So they don't want the witness brought in, late witness who's going to testify that it was a dog bite. Mandy Winslow says, I had jury duty this morning and sadly wasn't picked. Maybe next year. Mandy, I've never even been called in my whole life. Never received a letter say be on the lookout, not even show up at the courthouse. It's never happened for me. So better luck for you, I hope. All right. Let's see. Let me show you. Back to the Owens v. Eckerd. This is one of the things that I think should not be shown on a media pool feed. A brain emoji stream paused during trial break. It's cute. But I want to cut it out. So, or this. El gato no signal. Yo quiero Taco Bell, right? El gato no signal. Anyway, we'll get the Owens v. Eckerd a clean feed up, and as always, y'all are welcome. Y'all are welcome to use the feed for your enjoyment as far as viewing it and learning from it. And do reach out to me if you'd like to use it for your own use on your channel. Anyway, they're back there on that one. All right. Where do we go from here? I can't go there. There's a few. I've got enough equipment tied up right now that I'm a little limited in where we can go. It's a brain break. What are your thoughts on the motion hearing? Do you think it's more spinning the wheels? Dodie, I'm sorry you missed the hearing. You can go back and watch it. I cannot go to Judge Simpson now based on what how we're currently got everything tied up. Court hopping is out. Spinning the wheels, Hosanna Banana. You figured out the ergonomic issues. We don't have keyboard trays on desks anymore. We don't. Do you know why? Because tall people like me rip their knees open on them. My knees would always hit the keyboard tray. Like, I don't know how many pairs of slacks I've destroyed trying to sit at my desk at work. Karina, we have finished Karen Reed for the day. They took half a day off. We'll be back with Karen Reed on Wednesday to see what's on the thumb drive. Who wears pants at their desk still? Not me anymore, Greeners. The joys of working from home. I tell you, it's beautiful. Let's see where we are. We have another court. I'm trying to see if I can get this pulled correctly. 8, 7. Do I need 7? Don't need 7 where that's at. I'm only slightly frustrated now. This Owens v. Eckerd. Let's jump in really quickly and hear what's happening right now.
Stop the clock for a moment, and I'm going to remind the parties. Counsel, you ask a question. Ma'am, you answer the question. Otherwise, we move into a different area that I don't think anyone wants to go into. Counsel, resume.
Ms. Owens, you have been involved in court cases since at least 2016, correct?
Nonstop, or are you saying since 2016? Can you just rephrase the question?
Answer the question as I've asked it. You've been involved in court cases since 2016.
No.
Okay. This particular document, Exhibit A1, has 3 different types of highlighting on it, correct?
I see 2.
And Isabel, if you can please pull our Exhibit 17, page 110.
I wanted to see if there's any spiciness right now.
This is the same document, but I believe maybe when your office scanned it in, you can't see all the highlighting. So I'm going to show you ours. You see there's 3 different types of highlighting.
Yes.
And you highlighted this on the same Adobe Acrobat program that you used to alter the other records, correct?
This was the doctor highlighted point of care test results, and then I highlighted first trimester pregnancy and encounter for pregnancy test on my iPhone, but it wasn't Adobe Acrobat.
Okay, but you would agree with me, there's 3 different types of highlighting on this document.
Audio's
correct?
terrible. Anyway, we're gonna get that one fixed up. It's the attorney that's questioning the witness, who was the lady involved in the trial, refuses to stand at the podium where the microphone is. She wants to just stand there sort of like out in space. And the mic is trying to clip any background noise, which is what the lady comes across as. So, oh man. Okay. We don't have it up on Top Mark yet because I have to clip parts out of it. I might actually go. I would have to be off air to run it live stream on Top Mark now. It would be played back. Wait for it. Hang on, my brain's spinning. We're thinking here. Let me take the. If I were to play this in. Hit play here. Let me try something. If I were to do this here and take camera 8. I can play back the video. This is one of the things I love about the system I have now. I can play back the video while it's still being recorded. So this file is being written to on the back end, and I'm reading it on the front end, which is just awesome. But this is some of the issues we have with the case. I can skip through a little bit. Where does it start? Okay, let me do that. Let me wrap things up here, and because we've got a little bit of a break, and all my equipment's tied up in funky ways that I probably shouldn't have done this way, but I can't stop now or else I lose the whole recording. I'm gonna go over to Top Mark. I'm gonna start the live stream from the beginning of this paternity case with the Owens v. Eckerd. This is out of Maricopa County, Arizona. We are media on this. We're in the media pool on this. This is the feed that's been provided for us. Megan Fox is there in the courtroom. I've worked with her on this as well with making sure she has access, making sure we have access, and making sure the pool feed is available for everybody. So we're going to set that up. This is spicy. Let me just say this is not for everybody, and this is definitely not for kids. There's an argument over who's the parent. And when you're talking about who's the parent, some of the questions involve how you become parents. And so unless you would like discussion about that, be careful. Be careful. So let's do this. I'm going to take input here is going to be add to stage. Wait for it. Wait for it. How do I get my... on StreamYard, how do I get the label? Like if I'm the only person on screen, how do I get my label to not be on screen? Where it says Top Mark Media in the corner or RA. Anybody know? Layouts.
Have them send someone with more experience.
I don't know if I can do it. Vicky, are you gonna try to help me with this? Your messages.
When are we going to break for lunch, Judge?
We just broke for lunch. It's under brand. Show display names. Oh, you're beautiful. Thank you very much. Can I leave that off for the rest of my life? That would be wonderful. Okay. All right. So now we can. Vicky, thank you.
How does he do that?
I owe you. You saved my life there. All right. We're going to wrap things up here for today. I'm going to start the Owens v. Eckert over on Top Mark Media. This is supposed to be, I think, about a 2-hour hearing. Might go a little bit longer. They are under strict timelines. So this is fast. This is a paternity suit, and it does have some audio and video challenges, which I wish it didn't. But we'll jump over there, and in the meantime, we'll get set back on RA for some more stuff, probably tomorrow morning. So I think we're going to call it for today, even though it's just after lunch. How do we get there? We can make a link. Let's see. Can one of our mods put the link for Top Mark on there? And I'll go ahead and put this up live. Let me actually go live right now on Top Mark. Settings. Edit it. We're going to make it publicly listed. There we go. Save changes. All right, we just barely made it publicly listed, so you can go ahead and jump over there if you'd like to watch. I will not be commenting on this one, and there will be some points where there is prolonged silence, but that's cool. I'm cool with that. Add to stage. All right, we are now live on Top Mark Media, and they are hearing us now. For the rest of you who are over on Recovery Addict's channel, we're going to be wrapping up Recovery Addict as we start off on Top Mark Media. We're following the Owens v. Eckerd trial. This is not a trial, this is a hearing, a paternity hearing, which is a little bit spicy. Understand that this is a fast recording, a fast proceeding, because there are time limits, and so you got to talk faster to get everything you want in. That's just how the court runs. So buckle up, it's spicy. Here's your content warning. This has adult material in it. Proceed at your own risk. There you go. For those of you over on RA, thank you very much. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. Please stay safe till we go live again tomorrow morning over on the RA channel. We're going to go ahead now and kick off the proceedings with... let me do this. Let me turn off the RA channel. This is confusing. I should have waited. All right, we're gonna fade out RA here, and we're gonna go live with the proceeding out of Maricopa County here on the Top Mark Media channel. So if that doesn't confuse you, I don't know what does. I tried, guys. I tried. There we go. You guys, if you're over on RA, come join us over on Top Mark Media as we kick things off. Thanks a lot.